Jennifer Campbell, one of the co-chairs of the Executive Committee of the Beverly Hills Bar Association's Trust and Estate Section. Welcome to the Trust and Estate Section's monthly presentation today. Today we will be covering the intersection of family law and estate planning and administration. But before we begin, I have some housekeeping announcements for you. First, you will receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that is included with your certificate. Second, a word or two about our great sponsors. The Trust and Estate Section is sponsored by the Sanborn Team, Geffen Real Estate, Glen Oaks Escrow, California Title Company, and Manufacturers Bank. This program is also sponsored by Wayfinders Family Services and the Beverly Hills Bar Association Family Law Section. Let me please introduce Nancy Sanborn and Brian Joy of the Sanborn Team to say a few words.
Good afternoon. In these times of uncertainty and times of success, we have really appreciated the support of the members of the Beverly Hills Bar Association. We as real estate professionals have continued to move forward. Our needs have never been more clear.
We are fortunate to have a team behind us that has scaled up during this crisis as opposed to scaling back.
The Sanborn Team is a collaborative network of individuals always willing to take a call, answer an email, or brainstorm via Zoom or Google Meets.
We have learned how to handle offers, counteroffers, court confirmations, and overbidding in court.
We are a team that is committed to the satisfaction of our clients.
Change is inevitable. Challenges are certain. We are a brand of substance over stunts.
Each day we have been surrounded by partners and friends.
This is how we have achieved remarkable levels of success and having fun while doing it.
Again, just as you have supported us, we are happy to continue our support of the Beverly Hills Bar Association and specifically the Trust and Estate Section. Enjoy the meeting.
Thank you, Nancy and Brian. And now let me introduce to you Ulrike Gadish of Geffen Real Estate to say a few words.
Thank you, Jennifer. Hi, everyone. I'm Ulrike Gadish, the broker owner of Geffen Real Estate. I recently launched my first book titled The Practitioner's Handbook for Probate Real Estate. If you're a practitioner that's interested in reading it and writing a review, if you like it, let me know and I'll ship you a complimentary copy. Text me the number in the chat box. Also, my firm provides signature programs to give you the peace of mind when the estate you're managing has no funds and you're stuck with a property full of personal property and trash or needs repairs or renovation. We offer the Clear Out Now, Pay Through Closing, as well as the Repair or Renovate Now, Pay Through Closing programs. We also have programs that help you with getting your properties vacant, facilitating cash for keys with the occupants, and when needed, an eviction. Back to you, Jennifer.
Thank you, Ulrike. In addition to the Sanborn Team and Geffen Real Estate, the Trust and Estate Section is also sponsored by Glen Oaks Escrow. Marcine Klein is a full-service escrow officer specializing in probate, trust, sales, conservatorships, and both court and independent administration of Estates Act transactions. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that her clients are beyond happy with their experience at Glen Oaks Escrow. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans, military personnel, seniors, real estate agents, and brokers, as well as mortgage lenders and commercial real estate professionals. Manufacturers Bank invites you to simplify your banking. Let Manufacturers Bank do it for you. Manufacturers Bank has a dedicated trust and estates banking team with the experience to handle all your banking needs. Please contact Brian Flores, Vice President and Senior Relationship Manager, for more information. The Family Law Section, which is also co-sponsoring this program, is sponsored by Soberlink, White, Zuckerman, Wazowski, Luna, and Hunt LLP, and Our Family Wizard. And lastly, we have a few announcements. I hope you will save the date for our annual litigation update in May. You should be soon receiving promotional materials for that, and it will be on the Beverly Hills Bar Association calendar. Also, if you'd like to serve on the Trust and Estates Executive Committee, the application will be emailed this section and will also be available on the bar's website. Serving on the committee is a 5-year commitment and a great way to give back and have a good time doing it. Now, let me introduce Beth Acevedo, one of our legal update co-chairs, who will provide us with this month's legal update. Beth?
Thanks so much, Jennifer, and hi, everyone. This month, we have two cases that I'm going to talk about. The first being conservatorship of Doris May Broken. It's a 2nd District Court of Appeal, case number B303898, that was filed on March 15, 2021. In this case, Beth and Barry Broken filed a conservatorship proceeding on their mother's behalf over her vigorous objections. After 2 years of litigation and negotiation, the case settled before conservatorship was actually established. Beth and Barry sought to recover their attorney's fees as part of settlement. Their mother did not believe that they were entitled to fees, but to facilitate settlement, agreed to let the probate court decide whether fees should be awarded, and if so, in what amount. Barry and Beth argued that they were entitled to full reimbursement for their fees under Probate Code Section 2640.1a, which provides that if a person has petitioned to be appointed as conservator and another conservator is appointed while the petition is still pending, but not before the expiration of 90 days after issuance of letters, the person who petitioned for appointment of conservator but was not appointed may have that person's their fees and attorney's fees reimbursed, provided that the court determines that the petition was filed in the best interests of the conservatee. Beth and Barry also relied on the equitable principles set forth in the conservatorship of Cornelius to support their position. In Cornelius, a daughter petitioned for temporary and permanent conservatorship of her father. Temporary conservatorship was established, but the daughter ultimately dismissed the petition for permanent conservatorship. Nevertheless, the court awarded the daughter and her attorney's fees from the temporary conservatorship estate. In doing so, the court stated that the deciding factor in awarding reimbursement in a conservatorship proceeding is not whether a permanent conservatorship is established, but whether the expenses incurred were done so in good faith and in best interest of the proposed conservatee. In Broken, the trial court similarly granted the children's fee request, but on appeal, the Court of Appeal reversed. The Court of Appeal distinguished Cornelius from Broken, noting that Cornelius's focus was on whether the statutes allowing payment of fees to a conservator and her attorneys apply both to temporary and permanent conservatorships. The Court of Appeal concluded that the establishment of a conservatorship, temporary or otherwise, is a prerequisite to reimbursement for fees. Our second case is Ivor V Nord. This is a 1st District Court of Appeal case number A157962, filed on March 18th, 2021. In this case, shortly after her husband's death, Kay Pearson, who was 90 years old, executed a trust naming St. Jude's Children's Hospital Research Hospital as sole beneficiary, thereby disinheriting her estranged son and 2 granddaughters. Kay was close to her granddaughters until the last couple years of her life. Before executing the trust, Kay made statements to her friends that she was disinheriting her granddaughters for reasons that were demonstrably false. Following her death, Kay's granddaughters contested the trust on grounds that Kay had a mental disorder with symptoms including delusions and hallucinations that impacted her testamentary capacity. After hearing conflicting factual evidence regarding Kay's mental state and condition and why she disinherited her granddaughters, the trial court determined that at the time Kay executed her trust, she did not have a mental health disorder with symptoms of delusions that caused her to disinherit her granddaughters. On appeal, the Court of Appeal affirmed, stating that although Kay had demonstrably false beliefs about her granddaughters, and those beliefs motivated her disinheriting them, those beliefs were grounded in facts and therefore not delusions. In reaching its conclusion, the Court of Appeal noted that there was substantial evidence that Kay did not have a mental health disorder at the time she executed the trust, which was dispositive under the statute. I'm now going to turn things over to Megan so that she can introduce our speakers, who we're all actually here to see.
Thank you, Beth. I appreciate it. Today I'm going to introduce our speakers, Burton A. Mitchell and Stephanie Iblum. Burton Mitchell is the chair of the firm's Taxation and Trust and Estates Group at Jeffrey Mangels, Butler, and Mitchell. Burton's practice spans more than 30 years and focuses on taxation, estate planning, probate, trust law, and administration, trust disputes, nonprofit entities, and tax-effective financial planning within a family. Burton generally represents individuals, closely held businesses, institutional trustees, partnerships, limited liability companies, entrepreneurs, other professionals, and various members in the entertainment industry. Burton's practice encompasses taxation, estate planning, probate, trust law, and administration, trust disputes, nonprofit entities, international, and tax controversy. Stephanie Blum has practiced exclusively in the area of family law for 25 years and is a certified family law specialist, obtaining her certificate of specialization from the California Board of Legal Specialization in May 2003. Ms. Blum seeks to help those who face turmoil, uncertainty, and challenges of a divorce. She's been named by Southern California Super Lawyer, and prior to that, a Southern California Super Lawyer's Rising Star. Her philosophy in dealing with her clients is to bring sensitivity to what they're going through and to always treat every case on a highly individualized basis. Please welcome Stephanie and Burton.
Ready for us?
Yes.
Good morning, good afternoon, everyone. You may have noticed we're not at Lowry's. We designed this program to be given live, and it was put off twice. Once right at the beginning of COVID, then in the middle. We tried to put it off another time, but the Beverly Hills Bar Association wouldn't let us do it. So the way we have this structured is with a problem set. I learned a long time ago that if I just talk about the 3 reasons to do this and the 5 rules to do this, I could quickly put people to sleep. So we're going to talk about a hypothetical family, hopefully keep you awake even though you're not at Lowry's, and hopefully keep it interesting. We've all attended seminars where people tell you hold your questions to the end. Don't hold your questions to the end. You have something to say, just say it. I don't know how they say it, but
Just saying in the chat box, and I'm monitoring.
okay, so if you have something to say it in the chat box. It's being monitored by Megan, and we'll try to deal with it as we go along. Let's talk. So you should all have a problem set. I know it's been posted and distributed. The problem set's not critical, but it helps to follow along. So we're going to talk today about Harvey Hudson, H, and Wendy Hudson, W. They've been married for 21 years. He's now 45 years old. W is 46 years old. Notice the wife is older than the husband. Husband and wife have 2 children, Sam S, age 22, and Denise D, age 15. So Denise is a minor under California law, the D. There is not a prenuptial agreement or postnuptial agreement between H and W. There are no previous marriages, and there are no other children. Obviously, you could tell the fact pattern is fictitious based on that. All are U.S. citizens. The Hudsons reside in Hermosa Beach for some reason, in a luxury home 10 blocks from the beach, probably 1,000 square feet. The Hudsons are worth about $40 million, comprised of $30 million of community property, $10 million of H's inherited separate property. So that at least the facts are clear. We know there is separate property. In most of our situations with our clients, we don't really know. JMBM, Jeffrey Mangels, prepared H&W's joint estate plan in 2011. They have a joint living trust. It holds substantially all their assets, both their community and their separate. They have a standard engagement letter with JMBM and what we call a spousal conflict letter, which says that we're going to represent both of them in connection with estate planning, which is how it's normally done. H&W have now decided to divorce due to W's infidelity. We're an equal opportunity presenter. So here the wife was the one committing infidelity. Neither one has taken any concrete steps to a divorce. So we're going to talk about paragraph 2. The honeymoon is over. And question A is, who was president when H and W got married? So the facts tell us they've been married for 21 years. Stephanie, we're in 2021.
So in the year 2000, it was Bill Clinton. We remember that far back.
Right, and then George W. Bush got elected.
Right, in 2001.
Well, he got elected in 2000, right?
Right, but then he took office in
2001. Questions get progressively more difficult than that. 2B, H comes to you for pre-divorce advice. Any problems with that? Stephanie, any problems with talking to the husband, you don't represent the wife, about pre-divorce advice? No one's filed for divorce yet.
Well, problems for who? Problems for the divorce lawyer? It's not a problem for me. That's what I do for a living. But is it a problem for you if you prepared the estate plan for both parties? And I would put that question to you, Burton.
So he comes to me for pre-divorce advice. Yes, I think that would be a problem. We represent both H and W in connection with their estate planning. And I think to give advice to one party about a divorce would be a problem. The better part of valor would be to suggest that they go to talk to someone else, and preferably someone competent, like a family lawyer, like a quality family lawyer. 2C, H's family lawyer has a sentence in her engagement letter mentioning that they do not handle estate planning. The family lawyer does not do anything further in connection with estate planning. Any surprises here? Stephanie, you have a sentence in your engagement letter?
We actually have a whole paragraph that says we do not do estate planning and we do not give tax advice. And we say we recommend that you consult competent counsel for advice in those areas.
So should you do more than just put the paragraph in the cover letter? Should you grab that person by the neck and say, you really need to do something here?
I think it depends on their circumstances. I think when they're sitting with me, they're already dealing with quite a bit. So the estate planning is maybe not at the forefront of their mind. But I do think it's good advice to say, by all means, go, consult estate planning counsel.
And if God forbid somebody died at this stage, would H, they have a joint estate plan, presumably W is the primary beneficiary. Do you think H would mind that W is the primary beneficiary after she just cheated with his best friend?
Yeah, I think so. But if he's not going to get on it and talk to you, I'm not sure there's going to be much he's going to be able to do about it.
Or to someone.
Right.
Okay. 2D, can H change the beneficiary designation of his life insurance policy without telling W?
Well, what one can do and what one should do are different. This is a hard one because I did some research for this program and I learned that death benefits from a life insurance policy paid for with community funds are community property. So even if husband changes the beneficiary, if there actually is a divorce that goes forward, the court was going to the court's going to change it all up anyway. But can he? Yes, maybe, there's no automatic temporary restraining orders in place. We'll get to that. I don't know. What do you think?
He can change the beneficiary, and I think the insurance company, if he's the owner, will accept his beneficiary. What the family court will do is they will do something about it.
Right, if they're asked to.
Have you ever had a client die while at this stage or while the divorce was pending?
I've dealt with death. We had one recently. The wife, during COVID, I represented the husband. The wife died, and we had started to deal with a quadro issue, to deal with the division of retirement benefits because these were both elderly folks, and so we actually had an order that after the death, I asked the family court to vacate because it was my point was it was an interim step, and now the quadro is never going to happen because she's dead and he should get the money, and the court actually set aside the interim quadro.
But divorce, or in our case, we're in a pre-divorce step, is stressful.
Yes.
And people die, and divorces don't happen quickly.
Right. It can happen. It can happen.
It's happened to me a number of times, more than one would have thought. Sometimes because I think they wanted to. It was easier than going through the divorce.
Oh my God, that's...
2E, can H move some community property money, less than half, to a Swiss bank account that is unknown to W? He'll file the required FBARs.
Sorry, I don't want to interrupt. The question is, what if the change of beneficiaries from spouse to one of the adult children? Is that a breach of fiduciary duty? Will the family law court do the transaction?
So this is where we started, back on the life insurance. I guess everyone heard the question. So I'm going to repeat the question. Can can they change the life insurance beneficiary? Can H change his life insurance beneficiary to name an adult child? In this case, Sam is an adult child. And if he's the owner, I believe the insurance company will let him change the beneficiary to whoever he wants to name. But Stephanie, then what's the family court?
Well, but
let's assume he dies.
It also depends on how, this hypothetical gives dad $10 million of separate property. Did he use the separate property to pay for the policy? Because if you could, I mean, I think that's a real argument. If it was paid for with his separate property, then potentially, and it's not community, and he can designate who he wants, assuming it's not perceived as a breach of fiduciary duty.
So what if he paid with community property?
I think the family court can undo it, assuming he's not dead and they still have jurisdiction. If he's dead, then you're in probate court.
And I think they could undo it. Judges in family court are one step below those gods in Rome. They can do anything they want to do, and often do, and they dare you to appeal.
Right. It's an abuse of discretion standard. And, who's to say? And in my experience, the courts of appeal don't care that much. So yeah, I think trial judges in family law have a ton of discretion.
And presumably trying to do what's right.
Yes, presumably.
So what about 2E, Stephanie? H wants to move some money to his Swiss bank account, and he may have failed to mention it to W, sort of standard pre-divorce planning, move it out of the country into his own name.
Well, so spouses owe each other fiduciary duties, highest good faith and fair dealing. I'm not sure that having a Swiss bank account that he moves community property money into, comports with those rules. You're not supposed to be able to take unfair advantage of your spouse. But query, when they go to get divorced, does he disclose that this money is there? I think it's different depending upon whether he discloses it or he doesn't disclose it. And by the way, is that money held in the trust? Because you said that, most of their assets are held in this joint trust, and Family Code 761 says that a trustee can transfer trust property in accordance with the provisions of the trust. So I don't know, I guess is the short answer. But I don't think he should.
But if he moves millions of dollars, there's going to be a trail here.
Yeah.
What does he think he's accomplishing? Right. He thinks he's clever, or he watched too much television?
It's a bad idea, because then, of course, you start off in a divorce case and he's perceived by the judge as being dishonest.
And the W's always think the husband's secreting money, whether he is or not.
Well, you don't even have to make it sexist. I think husbands think wives are skimming off the top. So.
All right, let's go to 2F. Can H sell a community property building without the consent of W with title solely in his name? So his title is in his name. It's not in the trust. It's community property. He's not trying to steal anything.
Right.
He's just trying to sell it because he thinks it's a good time to sell, and the proceeds will be community property. Well, any problem with that?
No. Family Code 1100D says yes, he can sell it, but he needs to give prior written notice to his wife. So as long
prior written notice to entering into the contract
before he sells it.
By the time he's in escrow, it might be too late to back out. He doesn't need her permission.
No, but he has to, the code section says he has to give written notice. I don't know if people live their lives like that.
And generally. What if he doesn't do
it? Then he's in violation of the family code, and then it's up to your local judge to do whatever they're going to do about it.
2G is similar. Can she make gifts, W make gifts to her nieces without his knowledge or consent?
So the answer to this is surprising to me. Mm-hmm. It's no, she can't make annual gifts to her nieces without his consent. That's Family Code 1100B. It says that you need written consent for gifts unless the gift is given by both spouses or it's between spouses. Those are the rules.
Well, she has only community property here.
Right.
So she'd be giving away community property.
Right. Not allowed.
So presumably if she did it anyway, at some point there would be a reckoning.
Right. He would say, in a divorce, I'm owed reimbursement for that money. And he would get it, I think.
2H, what else can be done from the estate planning point of view before filing for divorce should be done if H goes to a new attorney or both H and W waive conflicts for representation of each of them separately. Well, I'm not sure what I would do here. I wouldn't do anything without both H and W knowing about it because of conflict.
You wouldn't even create a new will?
Only if they gave notice, one gave notice to the other. But I wouldn't want to do it in secret. But there's no divorce that's been filed. So they can do anything. They can change their will, they can revoke the trust, they can change beneficiary designations on retirement plans, on life insurance, they can change the healthcare power, they could do anything. And if H doesn't want to tell W he's doing it, there's probably other family trust and estates attorneys in the city of Los Angeles who would be more than happy to do it. So let's turn to paragraph 3, which is trouble in paradise. W now files for divorce. So now we're moved to a different circumstance. 3A, from an estate planning point of view, what documents control when W dies? Well, all she did was file for divorce. The wills and the trusts still say what they say, and they would still control from an estate planning point of view. 3B, does it matter whether H made a conscious decision not to do new estate planning or to let the existing documents stand out of ignorance? Well, this is similar to what we talked about before. W, she has a divorce lawyer, presumably she filed for divorce, presumably she didn't do it on her own. And her divorce lawyer probably has a paragraph in the cover in her engagement letter that says, hey, you should look at your estate planning. Whether she decided or he decides, I'm going to leave my estate plan alone. I've had a number of circumstances where the client says, you know, she's the mother of my children, and if she inherits the property, if I die during the divorce, it's okay. I know we're going to get a divorce, but you know, I'll deal with it later. And then I have other clients who go over my dead body. You know, let's change the
Everything.
Right, as quickly as we can. My big complaint with family lawyers is that they don't hit the client over the head with it. You know, that is, they don't say, hey, you really need to do it. They just have a paragraph in the cover letter, and there's so much going on.
They're so hit over the head with everything else. They now have to, I mean, what's going to happen to their kids? What's going to happen to their house? What's going to happen to their business? How much money are they going to receive? How much money are they going to have to pay? We're supposed to add that on top of it.
Don't forget the retainer.
Right. Right. And now they got to go pay that, you know, I want to be paid, and now I'm asking them to pay you. So yeah, it's a lot.
Yeah, they may say, I'll save some money now. Megan, we have a question.
People are just asking, Astros prevent changing the estate plan. I know it's coming.
The Astros questions are coming. 3C, would the estate planning attorney have changed the character property in 2011 when the client's estate plan was prepared? So the answer is, God, I hope not. The rule of thumb in trusted estates is you do not change the character. We represent both of them, and no matter what the clients tell you, it's dangerous to change character. And whether something is community or separate, it's clear in this problem set, but it's not clear in real life. Money is grabbed from whatever source for whatever purpose, and you can't always tell, and you can't always tell about expenses. You mentioned about the life insurance premium may be paid by separate property. You know, when there's a divorce, the forensic accountants have a field day of tracing every revenue source and expenditure over the life of this 21-year marriage. So there are a lot of cases where trust and estates lawyers have done documents which say everything's community property, and they did it for a good tax reason. But then they go to get a divorce, and those cases, there are a number of those cases where the party who had the separate property says, well, I did it for estate planning purposes. I didn't really do it for family law purposes. and the court doesn't want to hear it. If you transmute property, it's transmuted. And it doesn't take all that much trouble to transmute property. You just have to do a writing signed by the parties. So that lawyer very well might get sued at the end of the day for transmuting the property. So would the estate planning attorney have changed the character of the property? Hopefully not. 3D, what happens to the division of the parties' assets if W should die during the pendency of the divorce? So Stephanie, W filed for divorce, and then she proceeded to have an untimely death.
Right. So
Now what happens to your divorce?
it goes away. The divorce action doesn't survive a party's death, assuming the matter is not, we're not at the end of the litigation and it's under submission. So the divorce action's over, and now it's back in, back in probate court or back.
What should she have done immediately when she filed to avoid that?
Well, she should have changed her estate plan, but maybe she did. And we'll get to this, but maybe she's changed her estate plan to leave everything to DNS, the two children. Now she dies. How do I know what her assets are? How do I know I know it's community, but how do I know? He says he has $10 million as separate. Well, of course he'd say that. Presumably she won't agree with that. And the answer is the probate court finishes the divorce.
But she could also have given notice of severing a joint tenancy, for example, on a house. I mean, there were some things maybe she could have done at the beginning of a divorce case.
And we're going to get to that as things she could do. But the import of the question is that the probate court now takes over. It has exclusive jurisdiction, and it does the divorce.
Right.
What does the probate court judge know about divorce? Well, maybe he or she just served on the family court before.
Or sadly, maybe they know as much as a family law judge knows about divorce. So that's where we are these days.
But the answer is that's where the jurisdiction is, and we need to know what W owns for purposes of implementing her estate plan. So I'm up to, I think, 3E. How does W get H out of the house? So W files for divorce. She's got a minor daughter living in the house, and she wants to get rid of the husband. She doesn't want to look at him every day, which she just filed for divorce. The fact that she's cheating on him, the fact that she wants to be able to keep cheating on him now in her own house. That doesn't, well, okay, we'll get to that in a little bit. So how does she get him out of the house? And why does he have to leave the house?
Okay, in real life, how she gets him out of the house is she makes up claims of domestic violence. Now, that is not a recommendation. That's just what's going on. Otherwise, it's very difficult to get a spouse out of the house. It just is, because why, like you said, why does she have higher rights than he does? And then you can argue, well, the daughter, but the daughter's 15, and who knows who she's most bonded to, and she's taking care of herself from the perspective of her 15-year-old.
Would they ask the 15-year-old girl where she would want to live?
I hope not. I mean, eventually, if this divorce is actually going to go forward, someone is going to, either they're both going to have to leave the house or someone's going to leave the house. So, I mean, if I represented dad in that circumstance, I probably, assuming I cared about custody, I wouldn't leave the house without some custody orders either. So it raises all kinds of issues.
So it kind of weakens his position if he moves out?
Well, I just wouldn't want to hear, I don't know whether it really does or doesn't, but I wouldn't want to take the chance that, mom is going to come in and argue, well, you left, you don't care about daughter anyway. You can hear those arguments being made.
All right, so 2F, W is now in possession of the house. Somehow she got possession. Now she wants to turn around and rent it out and keep the rental income. Any problem with that?
Well, so this is a hard question because it's sort of got like two parts to it. Can she rent it out and can she keep the rental? So as for her renting it out, we have these ATROs, these automatic temporary restraining orders that limit some actions you can take after you file for divorce. And I'm not really sure that, renting it constitutes, encumbering or hypothecating the house. But as for keeping the rental, I mean, if wife were to do that and I represented husband, I would argue that the rental income obviously should be shared. And I'd want to charge her with what they call watch charges, because she now has the exclusive use of this community asset, and she's making money off it. And that's really money that belongs to the community.
Presumably she's going to go rent something in the interim and have an expense.
That was her choice. And for that, and maybe she's getting support in which, to pay for it.
So 3G, who gets Fido, the party's Labradoodle? This is, we're introducing a new family member, the Labradoodle, and that may be a more valuable member of the family than D. Did anybody argue about the dog?
Oh my God, yes. I actually had a trial where I've gone to trial a couple of times about the dog, and literally one judge, it was the longest I ever waited for a decision. They're supposed to rule within 90 days. He ruled on the 89th day. He was so tortured by the who gets the dog question. But since then, they've changed the statute. There's now a family code statute, 2605, and the court may assign sole or joint ownership of Fido. And it says that the court can take into consideration, the care of the animal, which includes but is not limited to the prevention of harm and who provides water and vet care.
And what about while you're waiting the 90 days or whatever for the order? Where is Fido for that period of time?
Where the parties, where the kids? It's sort of the same question.
Okay. By the way, I have the same problem in trust and estates. Who gets possession of the dogs if something were to happen to me? Forget my wife. Is vitally important. People care very much about their animals. Usually it's a dog. Sometimes it's a cat, but it's usually a dog.
Right, they're like people. I mean, right. People who like dogs think so.
They're better than people. They only are good natured and they only want to love you.
Right, exactly. They don't expect anything in return.
3H, what is the relevance? Well, this is another two-part question. What is the relevance, Stephanie, of W's infidelity? We keep talking about it. And then what if she gave H a sexually transmitted disease? I'm not sure how we know she gave it to him, but let's assume the questions speak for themselves.
Okay, so for better or worse, California is a no-fault state. So her infidelity has no relevance. I mean, I know people don't proceed like that, but it's not supposed to have relevance.
Do you slip it into the pleadings? And
some people do. Some people think it still has relevance. It's not supposed to. I think it was Ronald Reagan who got rid of it in like 1970. No fault.
Well, he was married a few times.
There you go. And as for the sexually transmitted disease, that's actionable. That's a tort, and you've got, I think, a 2-year statute of limitations to bring that claim. So
we're now up to 3I. We've talked about the ATROs a few times. What is an ATRO?
So an ATRO is an automatic temporary restraining order. Goes into effect as to the person who files when they file and the person who's served, the respondent when they're served, and it limits what people can do during the pendency of a divorce. You can't change beneficiaries of life insurance or any insurance. It's not just life insurance, health, car, etc. You're not. One of them also says you can't take the minor child out of the state without court order or prior written consent, and you can't encumber, sell, hypothecate, dispose of property, whether it's community or separate, during the pendency of the case, except in the ordinary course of business, or to pay for the necessities of life. And actually the form itself says legal fees. You can pay legal fees. So that is a necessity of life.
So W filed for divorce. What did she do to have the ATRO come into being?
It's a form that comes with the package of forms that are served.
It's automatic.
It's automatic.
She doesn't have to request it. He doesn't have to request it. It just every time.
When a divorce is filed, it's effective as to the person who filed once it's filed, and the person who served once they're served. So actually, I think that's something lawyers should consider when you're talking about when to serve a party and maybe when to file, because the sooner that a party is served with the divorce papers, the sooner the atros go into effect as to that party.
And we'll talk about what you can do or can't do, but if you violate the atro, you're violating a court order.
A court order.
At that point, which is probably not a good thing to do.
Not a good idea, but who knows what the consequence will be. I think it depends on your judge.
So we're in 3G. So now the divorce has been filed, the atro exists. Can H revoke H and W's joint living trust, and can we help them? Well, you answer the first question. They have a joint living trust. It usually says either side can revoke it on notice to the other side.
Right. Yeah.
Is that okay?
I think it is okay. I mean, that wouldn't be anything I want to do. I would rather, I would turn that over to you.
Right. And the question, can we help them? Remember, we have a conflict letter that says we're representing both of them. And we have a specific provision, which is approved by Ethics Council, which says we can prepare that notice on behalf of either party or both parties. Sometimes both parties request it, or generally by either party. If either requests it, we can do it. Under the terms of the joint living trust, it's generally not effective without notice. I think under the atros, you have to give notice. So I think that's consistent. Interestingly enough, I've seen it where we just do a document that just says I revoke the joint trust and send it to the spouse. I've sometimes seen it on pleading paper where we do it and then it's given to the family lawyer and they file it in with some other pleadings and it looks like a pleading.
Right. I think it's better practice. Like, for example, if you're going to eliminate the right of survivorship, like if you want to terminate the joint tenancy, for it to be effective, notice has to be filed and served before the changes take effect. So, I know that's for joint tenant, to sever that sort of thing, but
So you think it's better practice to do it it's in the pleading clip. No one's going to say,
right. I didn't get no, right. I don't know that it didn't happen. I wasn't served. My lawyer never told me. I think
I gave my homework.
Right, exactly.
Right, Fido, the Labradoodle. By the way, the Labradoodle is going to cut into their net worth. They're very expensive. So can H execute a new will and trust?
Yes.
So now, let's see, H revoked the joint trust. Now they both have no trust. And H now wants to do a new will and trust, and he wants to leave everything to his children, presumably, and cut out his cheating wife. That's okay.
I think so. He can certainly execute a new will. I don't know what happens.
I think he can execute a new trust.
Jeff or do it.
Say it again.
Can Jeff or do it?
Can Jeff or do it? So once the living trust has been revoked, I view the clients as severable. That is, if husband comes to us and says, now can you do a new will and trust for me? I think we could do a new will and trust. It's not adverse to W, it's its own estate plan. And can W come to us and say, do my will and trust? I think we could do it for both of them. Now, obviously, they're separate clients. New engagement letters, we can't disclose from one to the other what we've done.
Or would you get a conflict from them?
No, because I wouldn't give one the power to do it. I view the estate planning as separate. We'll get to what we can do in a few moments. But usually one or the other goes to someone else for whatever reason. I find it with accountants and business managers and wealth managers that there's usually a closer relationship with these people with one or the other, and one spouse or the other doesn't trust the other one. So it's for the family lawyers, it's a good referral opportunity to say, let me make a new referral to you for a new wealth manager.
Right.
You have 15 minutes if you want to get through some of this.
So when are we supposed to be done?
1:30, 1:35.
Okay, all right. So we just did 3K, 3L. Can W unilaterally revoke a joint tenancy? I think you've said yes. So you could just revoke a joint tenancy. Does it matter if the joint tenancy is real estate or brokerage account? Do you care what kind of?
I don't think so. I mean, I know for sure you can do it for real estate, so why couldn't you do it for a brokerage account?
I think it's not a problem. Can H move half of his community property to his new living trust? How about assets that are clearly a separate property? So we revoke the joint living trust. We create a new will in the living trust. Now H says, I want to move my asset to the living trust to avoid probate.
Heck no, not with those atros in place.
Well, what about the separate property? Why should the atros affect his separate property?
Because they do. They say separate or community. It encompasses all of it. I mean, you know.
So they don't care.
I guess you could go to court and ask the court for orders if you really cared.
I've seen people go to court. You also can go to the opposing counsel and say, look, this is clearly separate. You're not objecting to it. I want you to consent.
And they're going to say, and I want your client to pay thousands of dollars towards my fees. Would you like to make that deal?
You know, welcome to the world of family law. They will not give you anything for free. They'll want the labradoodle in exchange for something you're clearly entitled to.
Called leverage. You got to use it when you have it.
But otherwise, I'm stuck, right? I can't move my asset. And now,
not legally.
And now, if I die during this period of time, well, I have a will and a living trust.
The probate court ultimately will take care of it.
But I have a probate. And in this case, it's going to be it's a 10 million plus 15 million, it's a $25 million probate.
Well, you can take consolation in the fact that you're dead.
You're dead, and we're going to get legal fees off a $25 million probate.
So, you know.
And can H now change his life insurance beneficiary or retirement beneficiary? I think you've said no.
Right, those atros are still in effect.
So now W quickly got filed for divorce. His IRA 401k named W as the beneficiary, and he's on life support. She's like rooting for him not to make it because she's the beneficiary.
Yes.
And why would she be in a hurry to finish this divorce?
Right. Right.
God, you're cynical. Can H change his healthcare power of attorney or his financial power of attorney?
I think he can. I don't think the atros prevent him from doing that. I think it'd be crazy for him to not be allowed to change it for the reasons you were just alluding to.
I'm not pulling the plug on you. I love you too much.
Right, exactly.
I think that's okay. I think he could change his healthcare power and his financial power, but as long as he doesn't move any assets.
Right.
You know, I think he's okay.
Right.
Can JMBM prepare new separate estate plans for both H and W? That's the question, Megan, you asked before. Can W buy a new car? The divorce is going on.
Well, so I would argue that it's a necessity of, I guess you can argue it's a necessity of life. And the atros also say that if you're going to have an extraordinary expenditure, you have to give like 5 days notice. So I guess if you were really erring on the side of caution, I mean, I don't know what kind of car you're buying, right? Is it a $10,000 car? Or is it a Tesla?
It's a Lamborghini.
Okay, well, I think maybe you want to give notice unless there's 6 other Lamborghinis in your driveway.
Or how does support work during the period? Who gets interim custody of B? What about S, who is an adult? Can you help me with R? Because this is really outside my area of expertise.
Okay, so how does support work during this period? It can either work informally, where people just sort of maintain the status quo, or if somebody, the recipient, the person who would likely be the recipient of money isn't happy, they can go to court and ask for temporary support orders for child support, spousal support. So that's, it's either
Is it done by a formula?
So the court uses what's called the Disso Master. It's a software program, and it basically took the calculations that are set out in the family code, and it made it really easy for lawyers and judges to put in a few numbers, and it spits out a number, and that's guideline child support. And it also spits out a number for spousal support, which while the divorce is going on phase, the court can also adopt that number for spousal support.
And does it get thrown out if you make too much money?
So you can argue that there should be a deviation from guidelines. For example, if you're an extraordinarily high income earner and you can afford to pay any amount. And so if that was a child support matter, we'd be looking at the reasonable needs of the child. But if you're that rich, I can assure you that the reasonable needs of that child would not be perceived as reasonable by many.
Back to the Lamborghini.
Okay.
And is this a California thing that this will master?
Yeah.
If I said it in New York, they would go, what are you talking?
I think so.
Okay.
Burton, somebody wanted to know, can you avoid probate by general assignment in Hillside instead of the full blown?
So we would, in the living trust, we would put on Exhibit A. I definitely do an Exhibit A to the living trust that says all my assets. I would do.
Can you do the assignment? Can you do the assignment because isn't that a transfer?
I don't think you could do the general assignment. We would normally do a general assignment that says I transfer all my assets. I think that would violate the ATROS. I don't know. I've never done a Hegstead. A Hegstead's a way to avoid a probate to say just transfer those assets into the living trust. That's where they belong anyway. I've never done it under those circumstances. It's a really good question. If I had to answer yes or no, I'd say no. It shouldn't work. Can W continue to pay a boyfriend's condo homeowners association dues?
So she wasn't supposed to be paying it before. Use of community property after separation to support a third party is misappropriation.
Why is she finding this deadbeat boyfriend?
Because she has enough money after she gets half of the community.
I
And maybe
see.
support, she can go have a good time with whoever she wants now.
Apparently H has an illegitimate minor child. Thank God H finally did something wrong. So he is an illegitimate minor child. Can H continue to pay for that child's private school tuition? So is it different when we're talking about a boyfriend versus a child?
Yeah, so if he has a support obligation, then he actually has an obligation to provide support, and it's Family Code Section 915. But by the way, if he has separate property available at that time, he's supposed to be using that to provide the support. And here, this hypothetical, it talks about its private school tuition. So I don't know, is that part of the support obligation? I think courts would differ as to whether they would find it so.
So do I have 5 minutes left or 10 minutes left?
We can go a few minutes extra.
Okay, so let me try to whip through 4 and 5 because I don't want to leave people wanting more and hold them hanging out there. So we're under 4, we're a time to fight, a time to settle. The parties are near a settlement, whether it's a month later or 2 years later. Can JMBM assist with the settlement agreement? The answer is no. We represent both H and W, and we can't help with the divorce. I've had many a circumstance where we were involved with the estate plan. There's complicated estate planning. There's defective grantor trust. There's insurance trust. There's QPERS, and the family lawyers are will be totally lost on interpreting those trusts. And we can do it. We can help everyone with a new conflict letter. But absent a new conflict letter, we can't get involved. 4B, how do you know that the parties are near settlement?
They're out of money. Pay the lawyers.
You know when they're near settlement. You've exchanged drafts of settlement agreement. You can tell that you're getting close. Why should JMBM review the proposed settlement? Well, because there are these trusts involved and that we can assist. And I've seen settlement agreements where they award the life insurance to one side or the other, and it's in an irrevocable trust. They can't do what they just did and try to fix it afterwards. So I definitely think that trust and estate lawyers can be helpful to the process. Or if they had only represented one side, if they came in later in the process, then they could help with the settlement. If H and W swap assets, is that an income taxable event? No. So 1041 in the Internal Revenue Code, since Ronald Reagan was president, which was 1980 to 1988, the transfer of assets pursuant to a divorce is a non-taxable transaction, carryover basis. 4E, how do you handle an irrevocable insurance trust? What if the life insurance was awarded to W? This is a problem, and there's not much you can do about it. Sometimes we let the insurance go, you start new insurance, sometimes they keep it going. Maybe the spouse can do a disclaimer. It really depends what that insurance trust says. But one thing I know is it needs to be addressed. And sometimes the family lawyers in their haste to get the settlement will ignore these trusts, which they do so at their peril. 4F, H unreasonably refuses to settle. What now? What do you do with the litigant who's just unreasonable, just won't settle and just.
That's so unusual.
Right, how unusual. So usually when they do run out of money, they become more reasonable.
Well, so it depends on the goals of the parties involved. Like, it's usually to somebody's benefit to do nothing, and it's to the other party's benefit to do something. So it depends on which side you're on. And if you're looking to move the case forward, you start moving the case forward. You issue the discovery you need to issue, you file the request for trial setting conference, you force it forward.
And I guess eventually there's a trial.
Right, and so that forces either a trial or a settlement, but either way, there will be an end.
Are there actual trials in family court now?
Yes, well now, so most cases don't go to trial anyway, but yeah, the courts are functioning.
As much as they were functioning
Yes,
before.
right, exactly.
Is 4G, is bifurcation a sexually transmitted disease?
No, it is not. It's what we do when sometimes people just want to be divorced and they don't want to deal with all the other issues. So we table all the other issues and do what's called the bifurcation of status. So it makes them single people, but the court still has jurisdiction to deal with the property issues, the support issues, the custody issues at a later date.
Paragraph 5, the aftermath, the divorce is final. The parties finally signed a settlement agreement. 5A, how do you know the divorce is final?
The court entered a judgment. We have a stamp on a judgment of dissolution of marriage and a notice of entry.
And if you filed that paper with the court today, how long would it take to?
It so depends. Like I had somebody went in ex parte 2 weeks ago and got it entered the same day. The court bought the story that it was, an emergency, but because the husband wanted to remarry. If you send it down to court in the ordinary course, it depends on how backlogged they are. If there was a time it was 2 or 3 weeks, sometimes it's 3 months. I don't know.
I don't know how remarrying could be an emergency,
Right.
but 5B, W did an estate plan after the petition for divorce was filed. Does W need to amend her estate plan post-divorce? The answer is yes. We don't want any risk that the W is intestate or that the prior document matters. Marriage and divorce should trigger the requirement to do a new estate plan. It may be as simple as saying, I've reviewed my estate plan, I confirm it, but she should still do a new one post-divorce. 5C, can W now transfer assets to her living trust and change her retirement and life insurance beneficiary designations? Well, we're now in a new world, right? She's divorced. She can do whatever she wants. She can transfer assets.
Assuming it's not inconsistent with the judgment.
Well, she can only transfer her own assets, right?
Right.
Assets she controls. But she can live her life and she can deal with the trust and estate lawyer without the family lawyer telling her, no, you can't do that.
Right.
That violates the ATROS. 5D, are H's support payments tax deductible above the line or below the line? Does it matter if it's for child support or spousal support?
There's no more line.
Right, there's no more line. Child support was never deductible. Spousal support was deductible. It's no longer deductible, but it sunsets in 2025, assuming we ever get there without a change in the law. And old law will be back in 2026. And we'll do this seminar again between now and 2026.
Live at Lowry's.
At Lowry's, right. And finally, 5E, H forgot to disclose his Swiss bank account. Remember that Swiss bank account? S mentions it to W, so the son, who's an adult, mentions it to W. What now? Weren't releases signed as part of the settlement agreement?
Well, so there's a family code 2556 that deals with omitted assets. The court reserves jurisdiction to adjudicate them. And if it wasn't disclosed, if it was intentionally not disclosed, the court has the ability to award more of it to the party who didn't commit the breach of fiduciary duty.
So probably it's not a good idea to forget to mention the Swiss bank. I could see how one would forget it. If it's easily forgettable. That's it.
I just asked if there were any final questions, so you might want to just ask that as well.
We're here. We're happy to answer any questions.
Are you seeing any?
I guess we were so clear.
And everybody knows everything now.
Any labradoodle questions?
Oh, Ron Miller asked a question. Sorry, Ron Miller, can you repeat your question? I'm just having trouble finding his question. Sorry, 1 second. Ron, where is a divorce decree? Where a divorce decree is in place for husband's payment of a specific amount of child support, is the order definitive as to the amount, or is husband on the hook for additional money?
Okay, so typically when we fight about support, there's a base amount, which is what's calculated by Disso Master, but then we fight also about extras. So like extracurricular activities, who should pay them, unreimbursed medical expenses. So if the judgment is silent, then probably not, but usually good counsel will address these issues too. And you can always go and file a new RFO to ask for orders if these matters weren't addressed. Does that answer the question?
So they would like on private school tuition, you put something, if you could, in the order that says we agree to split the tuition or what?
Right. So, but that's not every court would order it. It depends if a child has special needs. It's a much better argument if a kid has special needs for the private school. Some judges will say, well, nobody can afford it, so whatever.
But let's assume the child goes to private school and the parents agree they should go to child support to private school, and they agree we're going to split it.
Okay,
so
then
you just put it in the order. The court won't object to it.
Right, of course not. But by the way, if they're agreeing, you're not going to probably have this. They're not involving lawyers.
Wouldn't we still file with the court so that you don't change your mind?
Yeah, I would. But if they're agreeing and there's no issues, then that's good.
Is there such a thing as an amicable divorce?
Yeah.
There's like 10 questions, but I'll choose one more.
Okay.
If under ASTROs, both spouses consent to a change of beneficiary designation on retirement accounts or insurance, is court approval required?
I think it's good enough. What I would do is I'd write it up in a stipulation in order, and I would say it's effective upon the signature by the parties, and I don't think there's any issue because the courts don't care. The courts only care when parties come to them and say, he did this or she did that and she shouldn't have. So.
You want to do more? I'm happy to do more.
Okay. Husband
I got nothing else to do.
We're not busy. If husband uses community property assets to pay large sums to his family employees, presumably as a way to hide assets, would that kind of payout be prevented by ATRO with the sums be recoverable?
By ATROs, well, it's disposing of property. Is that the ordinary course? Has he been doing it their whole marriage?
No, I mean, I've seen it where there's like a two-person business and you want to pay money to the other guy on the theory that he'll hold that money for me and give it back to me after divorce, and I trust him to do it. But that's
it's a fraud. It's a fraud. If you can prove it or get a court to believe it, I think you got a problem.
Okay, so one last question, which I think is an easy question. What does ATRO stand for?
I think you actually answered that question already.
Automatic temporary restraining order.
So I want to thank Burton and Stephanie for their time today. And if you have any follow-up questions, feel free to email both of them. Neither of them are busy.
No problem.
We'll be happy to take your questions. Thank you everyone for attending.
Thank you.
Thank you.
Thank you very much.